I received an inquiry today from a person whose property of the father was still in the custody of the police station, notwithstanding that a charge was filed against the father and he had been sentenced in accordance with law, dijatuhkan hukuman. How does she get her father's property back? So I won't go into more details in the case, whether, who has the locus, who has the right to retrieve their items. This is about how you can recover your property, which is in the custody of the police. Now, we all know that we have some constitutionally guaranteed rights, Article 13 of the Federal Constitution, and the state also has the duty to ensure that if they're going to deprive us of our livelihood, that it must be done in accordance with law, Article 5. And the state action must be done according to due process and procedure. This has been discussed in many case laws, Siva Rasa Rahsia, Article 5, Article 8, and the like. So there's two avenues that we're looking at. We are looking at Section 413 of the Criminal Procedure Code. If you have your items taken by the police, first you need to determine why do they have it. Is it properly seized as a barang case, or it happens to just be in the possession of a police officer? You need to determine that. They need to have actual basis to detain your property, because the police, they function under law. So if they have no legal basis to have possession of your items, then they have no right to. There could be something unlawful, and you can get a court to order them to return the goods. All right. Even if they have basis, sometimes the legal basis, the law that provides them the power to seize your items, there could be limitations conferred upon the police to do so. For example, they can only seize items for a certain period. For example, freezing orders under our anti-money laundering laws, or they can only seize your possessions if they have reason to suspect that it has been used in a crime, or it is the proceeds of crime, or it is has barang curi and the like, or perhaps they are implements of their weapons under the CHOW, Corrosive Explosives and Offensive Weapons Act, and the like. There could be legal basis to do so. That being said, the court still has the power under Section 413 to make orders in respect of items in the custody of the police, so that the police shall deal with these items accordingly. Okay, so if the item seized has been identified as barang case, relevant to an investigation, relevant to proving and establishing a case, the court can still make the order under Section 413. And this order can be made not just at the end of a trial, or at the end of an order of DNAA or whatnot, or an NFA. Even if there's a decision to charge, that the court can make those orders. I know this because over a dozen years back, there was a case in Penang involving a truckload of stolen microchips. I think they were microchips, transistors, and I'm not sure if they were new or they had been used already. So due to the cost of these microchips, that holding them might diminish the cost of it if it was resold, and it may negatively harm the complainant. Thus, it was decided and agreed that the court will make an order under Section 413, notwithstanding, if I'm not mistaken, there were no charges filed at that time. Notwithstanding, no charges were filed. However, there was a file open, and the identification of the exhibits was used in the trial later, when the alleged thief and alleged recipient of stolen goods under Section 411 was eventually arraigned and charged and tried in court. I don't remember what happened to that case, but that's an example where 413 was used for a truckload of microchips before full trial. Okay, and there are certain tests and category and criteria for you to move the court, to persuade the court to use its power in that scenario. I'd like to share another example where at the end of a remand, remember 413 is different from remand under 117. Sometimes in the course of arrest, there would have been, let's say, a handphone of a suspect who had been detained for the purpose of investigation, or just detained for whatever reason. Okay, so at the end of the arrest, when the case was called up for purportedly for extension of remand, the magistrate of Kajang dismissed the IO's, or rather the IO Ganti's application to extend remand. The actual IO was not there, but that's another matter entirely. At the same time, the learned counsel requested for an order from the magistrate that the police release the handphone of the suspect that was detained at that time. So the counsel didn't just simply attend court. He was prepared to make that application. It's not a common application, but he was prepared because he suspected that there is a possibility that the authorities might detain that handphone for some collateral purpose. Because between the suspect and the complainant, there were multiple other controversial cases, so to speak. So the magistrate did order for the release of that handphone, but Section 413 specifically was not invoked. And satu kerja juga, notwithstanding the magistrate's order, it was still a task for us to get that handphone back. One of the reasons we suspected, but it was not really an issue before us, is because the court has, under Section 117, at that time the court is only concerned whether to grant an order of to extend remand or not, and it was not concerned about barang case, but still gave the order. So one might say that it was not a properly made order. Okay, it was ultra virus, etc., but it's still an order, right, until it is set aside. So eventually the police did release that handphone, but I suspect they released it under another different power, and that goes into my second subject. Just now I'm talking about 413. Another subject is that the police can just release the property on their own. They can. It is an administrative effect. When in their view they don't need your property, they can just release it at any point in time and for whatever reason, with or without black and white. When they seize it, if it is for legitimate purpose, for example, they should issue a borang bongkar or something else, or if there's nobody at the scene where they made the seizure, they should make some kind of police report to document it, like in KPDN cases. When there were raids, when the police made raids on premises where there's nobody supervising it, they still make a report to document that, what was actually seized, notwithstanding that the persons there had already vacated, had absconded, right? So just because you filled a borang bongkar doesn't mean that you admit that item was yours. But the description in the borang bongkar which probably show that you are in possession of it. It is not a document to title to establish that you actually own it. Okay, there's a number of well-known case law on the subject, but the police can still release it nonetheless. When they release it, make sure. Here's a takeaway point for my dear friends. Please make sure that you have it in black and white when they release it, and for what. And if they don't, I don't know, follow up with a letter or something, or some other way of documenting it. Some of us just make a police report for the darndest reasons. I can't encourage that for this particular purpose. But maybe you're right, and just record it on this particular date. You return this item to me, so that that they could be that could come in handy if you need it in the future, right? At the end of a trial, it is normal for the court to order that barang kes dikembalikan kepada pihak pendakwaan untuk dilupuskan. If it's important enough for you, and let's say you're a witness or a third party, or even if you're the accused, right? If it matters enough for you, you should do something. You should somehow intervene legally, get legal advice on how this could be done to protect your interests in respect of that property. Because what if it affects some third party rights? What if it belongs to some third party? You're holding it on trust. You could expose yourself to civil liability if you did not protect your turf, so to speak. Notwithstanding that, you might think that you can rely on a court order to defend yourself. Not necessarily. May or may not be effective. So you might want to intervene and say that it be released to a third party. The court doesn't always have to release it to the prosecution in every situation. They can release it to you, to the victim, etc., etc., under process of law. But the court should, of course, be satisfied of its reasons. Not just reasons, but back it up with evidence, with something substantial. And it helps if the prosecutor doesn't object either. So you got to get the prosecutor on your side to make this work. Please also note that there are some laws out there that call for the pelucutan or pemusnahan of barang case. I mean, if it is related to the actual offence, let's say related to pollution, let's say related to cetak rompak, let's say related to pornography, there are specific provisions giving the authorities and or the court specific power, or that they must musnahkan, to destroy this barang case. So fat hopes of you attempting to recover them. But maybe you can, I don't know, apply for a stay of the order pending your appeal or something to such effect. My expectation is that they won't be destroyed until the termination of appeal. I believe that is the case. Sometimes you might want the items back, but you do not want to be identified as the owner for whatever reasons, for legal reasons, social reasons, political reasons. So you need to make sure that there is an intervention either by yourself or by some other legitimate third party. So the way to do this, either the relevant applications to court, or write letters to the AG's chambers, CC the court, to the authorities, etc., etc. Okay, so I think these are proactive measures that you need to undertake to protect your rights to property. Because if you sit back on it and if you do nothing, the authorities can just hold on to your properties indefinitely. There are cases which have been finished years and years and years, and there's so many personal belongings of suspects that are still in Balai Police because they were not taken by the IO. They were taken by the operations officer who did the arrest, for example. And these items, personal items, were not made into barang case. They were not exhibited in court, so nobody knows their whereabouts. So you need to trace their whereabouts. The first port of call is, of course, the investigating officer. And I think there's other avenues that you can trace the whereabouts of the items. Please get legal advice on this, and my best wishes to you. All the best. Speed is of essence. Otherwise, if you sit on your rights, they will disappear. You don't know if your property might end up inadvertently in somebody else's pocket and maybe resold or fenced out.